Islands and sharing your expertise with everyone here.
Call on the elected member for Bordentown West to say prayers.
Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech thee so to direct and prosper the deliberations of the Legislative Assembly now assembled, that all things may be ordered upon the best and surest foundation for the glory of thy name and for the safety, honor, and welfare of the people of these islands. Bless our sovereign lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established amongst us. Especially we pray for the governor of our islands, the premier, the speaker of the Legislative Assembly, the leader of the opposition, ministers of the cabinet, ex-officio members, and members of the Legislative Assembly, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for thy great name's sakes. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be thy name, thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keeps us. The Lord makes his face shine upon us and be gracious unto us. The Lord lift up the light of his countenance upon us and give us peace, now and always. Amen.
Please be seated. The assembly is now in session.
Oath, administration of oaths or affirmations. Oath of allegiance and due execution by Dr. Dax Bastillo, the acting Honorable Deputy Governor, responsible for the portfolio of the Civil Service, to be the temporary ex officio member of the Legislative Assembly.
Please.
I, Dax Krishna Basdeo, do solemnly and sincerely affirm and declare that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors, according to law. I, Dax Krishna Basdeo, do solemnly and sincerely affirm and declare that I will well and truly serve Her Majesty Queen Elizabeth II, her heirs and successors, and the people of the Cayman Islands in the office of Member of the Legislative Assembly.
Mr. Basdeo, we welcome you to the House as the Acting Honorable Deputy Governor responsible for the portfolio of the Civil Service, to be the temporary ex officio member of the Legislative Assembly. You may take your seat, sir. Please be seated.
Reading by the Honourable Speaker of Messages and Announcements.
None.
Presentation of petitions.
None.
Presentation of papers and of reports.
None.
Questions to the Honourable Ministers and members of the Cabinet.
None.
Statements by the Honourable Ministers and members of the Cabinet.
None.
Personal explanations.
None.
Obituary and other ceremonial speeches.
None.
Raising a matter of privileges.
None.
Government business. Bills. Third readings. The Freedom of Information Amendment Bill 2019.
The Honorable Attorney General. Third reading.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move for the third reading of a bill, the short title of which is the Freedom of Information Amendment Bill 2019, and that it be given a third reading and pass.
Question is that a bill shortly entitled the Freedom of Information Amendment Bill 2019 be given a third reading and passed. All those in favor, please say aye. Aye. Those against? The ayes have it. The Freedom of Information Amendment Bill 2019 has been read a third time and is passed.
The Trade and Business Licensing Amendment Bill 2019.
The Honorable the Minister of Commerce.
Mr. Chairman, I beg to move that the bill shortly entitled the Trade and Business License Amendment Bill 2019 be read a third time and passed.
Question is that a bill shortly entitled the Trade and Business Licensing Amendment Bill 2019 be given a third reading and passed. All those in favor, please say aye. Aye. Those against? The ayes have it. The Trade and Business Licensing Amendment Bill 2019 has been read a third time and is passed.
The Customs and Border Control Amendment Bill 2019.
Honorable the Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that a bill shortly entitled the Customs and Border Control Amendment Bill 2019 be read a third time and passed.
Question is that a bill shortly entitled the Customs and Border Control Amendment Bill 2019 be given a third reading and passed. All those in favor, please say aye. Aye. Those against? The ayes have it. The Customs and Border Control Amendment Bill 2019 has been read a third time and is passed.
Motions. Government Motion Number 3 of 2019-2020, Cayman Islands Constitution Amendment Order 2019, to be moved by the Honorable Minister of Employment, Border Control, Community Affairs, International Trade, Investment, Aviation, and Maritime Affairs.
Honorable members, yesterday the House suspended the relevant standing orders for the motion to move forward. Call now on the Honorable the Premier.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move Government Motion Number 3 of the 2020-2021 session of the Legislative Assembly, entitled Cayman Islands Constitution Amendment Order 2019. Whereas the passage of an amendment to the UK's Sanctions and Anti-Money Laundering Bill 2018 brought into question issues regarding the constitutional relationship between the United Kingdom and the Cayman Islands. And whereas the Premier had audience with the Prime Minister of the United Kingdom on the 15th of May 2018, and subsequently participated along with other overseas territories' heads of government in a teleconference with the Prime Minister on the 24th of May 2018 to discuss the results of the debates in the House of Commons and the House of Lords regarding the passage of the amendment to the Sanctions and Anti-Money Laundering Bill. And whereas on the 17th of May 2018, the Premier met with the Chancellor of the Duchy of Lancaster, who was appointed by the Prime Minister to oversee the constitutional discussions to set out the concerns of the Cayman Islands government. And whereas on 30th of October 2018, after consultation with the then leader of the opposition, the Premier formally submitted a document to Lord Ahmad of Wimbledon, Minister of State for the Commonwealth and the United Nations, entitled Draft Proposals for Discussions with the UK Government on Constitutional Revisions. And whereas a delegation comprised of the Premier, Leader of the Opposition, 2 ministers, Deputy Leader of the Opposition, Attorney General, and other government officials met with officials from the Foreign and Commonwealth Office and discussed potential amendments to introduce further constitutional safeguards on the 7th and 10th of December 2018. And whereas following the discussions held in December 2018, a first draft of an order in council was sent to the Premier on the cover of a letter dated 6th of January 2019 from Lord Ahmad of Wimbledon, Minister of State for the Commonwealth and United Nations, for the consideration of the Cayman Islands government. And whereas on the 24th of April 2019, a letter was submitted by the Premier to Lord Ahmad of Wimbledon, Minister of State for the Commonwealth and United Nations, seeking further consideration of a number of key proposals not addressed in the first draft of an order in council. And whereas on 10th of November 2019, the Premier received a letter from Lord Ahmad of Wimbledon, Minister of State for the Commonwealth and United Nations, that was accompanied by an updated draft Cayman Islands Constitution Amendment Order 2019. And whereas on the 20th of November 2019, the Premier and the Leader of the Opposition indicated in a joint letter to Lord Ahmad of Wimbledon, Minister of State for the Commonwealth and the United Nations, that although the changes represented in the draft Cayman Islands Constitution Amendment Order 2019 are not minor, they are nonetheless uncontroversial, and therefore in such circumstances, a referendum is neither necessary nor appropriate. And whereas the United Kingdom government, by way of a letter dated 10th of June 2009 from the then Parliamentary Under Secretary of State, advised that where such a declaration is made by the Premier and the Leader of the Opposition, a referendum may not be necessary, and in which case a resolution of the House would be sufficient. And whereas pursuant to the letter from the United Kingdom Parliamentary Under Secretary dated 10th of June 2009, a resolution of the Legislative Assembly approving the proposed draft Cayman Islands Constitution Amendment Order 2019 is now sought. Be it therefore resolved that this Honourable House does approve the proposed amendments to the Cayman Islands Constitution Order 2019, as set out in the draft Cayman Islands Constitution Amendment Order 2019, sent to the Premier of the Cayman Islands, the Honourable Alden McLaughlin, on the cover of letter dated 10th of November 2019, from Lord Ahmad of Wimbledon, Minister of State for the Commonwealth and United Nations, subject only to delaying the coming into effect of the proposed amendment under Section 44, Subsection 1 of the Constitution until after the next general elections. And be it therefore further resolved that a copy of the resolution of this House and the transcript of the debate on this motion be forwarded to the Foreign and Commonwealth Office upon completion of the debate and the vote thereon.
The question is that be therefore resolved that this Honourable House does approve the proposed amendments to the Cayman Islands Constitution Order 2019, the Constitution, as set out in the draft Cayman Islands Constitution Amendment Order 2019, sent to the Premier of the Cayman Islands, the Honourable Alden McLaughlin, on the cover of letter dated 10th of November 2019 from Lord Ahmad of Wimbledon, Minister of State for the Commonwealth and the United Nations, subject only to delaying the coming into effect of the proposed amendment of Section 44(1) of the Constitution until after the next general elections. And be it therefore further resolved that a copy of the resolution of this Honourable House and the transcript of the debate on this motion be forwarded to the Foreign and Commonwealth Office upon completion of the debate and the vote thereon. The motion is open for debate. The Honourable the Premier.
Thank you, Mr. Speaker. Mr. Speaker, before I go into the detail of what the constitutional changes will entail, I think it might be helpful not only to members of this House but to the broader public if I explain a bit about how we get to this point and what this process we're going through today will involve. Mr. Speaker, the current Cayman Islands Constitution Order 2009 was approved by the electorate on Election Day in May of 2009. It was the product of some 9 years of constitutional discussions and negotiations, not just locally but also with the United Kingdom government, involving 3 full rounds of talks in the United Kingdom, at Lancaster House, and in Cayman. And so there was an exhaustive consultation period involved. Following the coming into effect, Mr. Speaker, following the successful referendum vote approving the Constitution Order 2009, the Cayman Islands government wrote to the United Kingdom government regarding the process to be followed with respect to any further changes to the Constitution, and suggested that such changes of real significance or involving controversy ought to be the subject of another referendum. Mr. Speaker, on the 10th of June 2009, when you were then leader of government business, 10th of June 2009, before the Cayman Islands Constitution Order 2009 came into effect, the then Minister for the Overseas Territories, styled as Parliamentary Under Secretary of State from the Foreign and Commonwealth Office, wrote to you in the following terms: Dear Mr. Bush, as part of the constitutional modernization process, the Cayman Islands government made the following proposal. After the present modernization process has been completed, further changes to the Constitution should not be made without the authorization of a referendum, unless the change is declared by the Premier and the Leader of the Opposition to be minor or uncontroversial, in which case a resolution of Parliament would be sufficient. The United Kingdom government should be invited to agree that it would honor this referendum requirement. That was a quote from the letter written by the Cayman Islands government. The minister responded, in general, the United Kingdom government approves the idea that substantial constitutional changes should be supported by the people of the Cayman Islands in a referendum. Accordingly, the United Kingdom government would normally use its best endeavors to honor this referendum requirement. However, there may be exceptional circumstances where it would not be possible or appropriate to do so. And for that reason, the United Kingdom government must reserve its position on the matter. So, Mr. Speaker, following that, during the last term, there was a significant change, amendment to the Cayman Islands Constitution Order 2009 relating to the tenure of judges of the Grand Court, increasing the age at which they could remain in office from 65 to 70. Mr. Speaker, those changes were not the subject, which were being proposed by the United Kingdom government, were not the subject of any consultation at all, not even with the Judicial and Legal Services Commission or the Constitutional Commission. The United Kingdom requested the support of the Premier and the Leader of the Opposition for the changes. I signed a letter as Premier indicating my support for the changes, and the United Kingdom government then proceeded to effect the changes by order in council. I raise that, Mr. Speaker, so that it is clear that even with respect to the current constitution, changes have already been made without the referendum process being invoked. Mr. Speaker, the motion has set out the chronology of events which have given rise to today's motion. I have already laid on the table of this Honourable House the letter of 10th November 2019 from Lord Ahmad, the Minister for the Overseas Territories, to me, and the accompanying draft order in Council, which sets out the proposed constitutional changes. And I do not propose to lay those again, but I do think, Mr. Speaker, that it will be helpful to the narrative and appreciation of what we are doing if I were to read again the letter from Lord Ahmad and the response from myself and the Leader of the Opposition, which has really been the trigger to bring us to this point. The joint letter. The letter from Lord Ahmad reads as follows: Dear Alden, Constitutional Reform. I am writing to provide an update on plans to reform the Cayman Islands Constitution. I am pleased to confirm that I have been able to secure agreement within the United Kingdom government to a final package of proposals that accepts the majority of your suggestions, ordered in Council at Annex A, that's the attachment. Of your counter proposals, we have been able to accept your request for a provision in the Constitution that the United Kingdom will consult the Cayman Islands on any legislation affecting them, and a narrower definition of the Governor's duty to consult Cabinet. I am sure that you will agree that this is a positive development, not just for the future relationship between the United Kingdom and the Cayman Islands, but also for the future governance of the Cayman Islands. I have welcomed the fact that our bilateral discussions to date have included representatives from both the government and opposition in the Cayman Islands. As you know, the next step in agreeing the package is to obtain the broadest possible cross-party and public support for these reforms. Generally, the policy of the United Kingdom government has been to require a referendum unless the reforms are declared by the Premier and the Leader of the Opposition to be minor or uncontroversial. However, I would also note that the UK government's position on this matter is reserved, as there may be circumstances where a referendum may not be possible or appropriate. Therefore, I would be grateful if you could outline how you intend to seek the broadest possible support for the reforms to the Constitution, both within the Legislative Assembly and the wider public. If the decision was not to hold a referendum, it would be helpful if you could explain the case for not doing so. I would be grateful for your views on the final package of constitutional reform proposals. Subject to the points made above, if you agree to the package, the Foreign Affairs Committee will be notified, and the draft order in Council will be sent to the Privy Council for the order to be made. You will also have seen that a general election has now been called, and under the rules of PERDA, I will not be able to make any new decisions that bind any further government. Yours sincerely, Lord Tariq Ahmad of Wimbledon. Mr. Speaker, following that letter, there were discussions between myself and members of the opposition, and indeed a meeting with myself and the Honorable Leader of the opposition. And subsequent thereto, we agreed to write to Lord Ahmad in the following terms. Mr. Speaker, I have to confess I don't have a copy of the actual letter, although I have the draft, which doesn't have a date. No, the one that we sent. Thank you. My thanks to the member from Georgetown Central, who did have a copy. Mr. Speaker, the letter is dated the 20th of November 2019 in the following terms. Dear Lord Ahmad, Reconstitutional Reform. It is signed by myself as Premier and by the Honorable Art McLean as Leader of the Opposition. We refer to your letter of 10th November 2019, together with the draft Cayman Islands Constitution Amendment Order 2019. We refer in particular to your request to seek the broadest possible support for the reforms, both within the Legislative Assembly and the wider public. To that end, we are pleased to advise that following discussions with members of the Legislative Assembly, we have agreed on the package of reforms as contained in the draft order, subject only to the coming into effect of the provisions in Section 5 relating to the additional minister being deferred to the start of the next term, that is, until after the next general elections. Indeed, we are of the opinion that although the changes are not minor, they are nonetheless uncontroversial. In such circumstances, and in accordance with your letter, we believe a referendum is neither necessary nor appropriate, and instead our agreement to the reforms will eventually be confirmed through a resolution in the Legislative Assembly. This is an approach confirmed as acceptable to the United Kingdom government in a letter dated 10th of June 2009 from the then Parliamentary Under-Secretary Chris Bryant. In this regard, we undertake to provide you with the relevant Hansard transcript of the resolution by the Legislative Assembly at the conclusion of the debate on the package of reforms. However, we consider that the consensus reached by us in confirming our agreement to the reforms is of such significance as to justify notifying you without further delay. Mr. Speaker, I would ask your permission to lay a copy of this letter on the table of the House because this is not yet a matter of public record.
So ordered.
So, Mr. Speaker, that is the point at which we now are. Mr. Speaker, I should say this. I know every member of this House, myself, principal among them, would wish that we had the opportunity for much wider consultation, much broader consultation, and a longer period of time in which to do so. But, Mr. Speaker, I think it is important that everyone appreciates where we are in the election cycle with the United Kingdom government. And it is, I believe, Mr. Speaker, these sorts of events that were in contemplation by the Minister, the Parliamentary Under-Secretary of State at the time, Chris Bryant, when he wished to reserve onto the UK their ability not to require a referendum in certain circumstances. He said in the letter, there may be exceptional circumstances where it would not be possible or appropriate for a referendum to be held. And for that reason, the United Kingdom government must reserve its position on the matter. Mr. Speaker, as I indicated, the letter from Lord Ahmad was received on the 10th of November. We were able to reach agreement among members of this House on both sides on the 20th of November. The United Kingdom's general election will occur on the 12th of December. And this deal, if I may call it that, will fall away. The offer will fall away if it is not agreed to prior to the general elections, because the minister, and indeed the entire government, loses power on election day. And thereafter, regardless of the outcome of those elections, it would be a matter of having to restart this process. Presumably, were the Conservative Party to win the government again, the arrangements would be honored. But there would be no concluded arrangement at that stage. Were another party to take power, one never knows what their attitude may be to the constitutional relationship between the overseas territories and the United Kingdom. And so, Mr. Speaker, all of us in this House, I believe, and I believe I can safely say all of us in this House, have weighed in the balance all of these considerations and have concluded that the arrangements which we have managed to negotiate with the United Kingdom are of such constitutional importance and such importance to the long-term interest of these islands that we must seize this opportunity and approve these arrangements in advance of the United Kingdom general elections on the 12th of December. And so, Mr. Speaker, that brings me conveniently to this point, the point which started these, or initiated, precipitated these constitutional discussions in the first place. Mr. Speaker, I can say with hand on heart that the furthest thing from my mind when I took office for the second time as Premier in May 2017 was getting involved in protracted constitutional discussions with the United Kingdom. I spent the first 9 years of my political career involved on one side or other of this House in that battle. And I did not want to be distracted from all of the other critical things that the government needed to be doing by constitutional discussions, because I know full well how controversial they can be. But, Mr. Speaker, the events which arose last year when the Sanctions and Anti-Money Laundering Bill was being moved through the UK Parliament, and efforts were made and indeed succeeded in attaching amendments to it which legislated for the overseas territories with respect to critical aspects of our financial services industry, outraged and seriously worried all of us who are leaders within the overseas territories. And indeed, Mr. Speaker, our financial services industries in particular. Mr. Speaker, that is why in the motion I refer to my meeting with the then Prime Minister of the United Kingdom government and the Chancellor of the Duchy of Lancaster, who was essentially the Deputy Prime Minister, in everything but name, as well as the teleconference between myself and all of the other overseas territories leaders and the Prime Minister about this. Because, Mr. Speaker, we believe, although the United Kingdom government will never admit that, I'm sure, that this constituted a constitutional overreach. All of the territories operate on the basis of constitutional orders which have devolved responsibility for legislating and for administering the affairs of the territories. There are different degrees of autonomy which we enjoy depending on the territory and its level of advancement. But to one degree or another, we all are devolved administrations. And for the United Kingdom Parliament to impinge upon that devolved responsibility by purporting to legislate in areas of domestic policy was something that gravely worried and gravely worries all of us, because it isn't just the areas of financial services that can potentially be impacted if this were to become the norm, but just about any aspect of domestic policy here that they disagreed with, or things that they wish that we would do and we won't do. In fairness to the United Kingdom government, they too were very concerned about this, and we all know that the reason why these sorts of things were able to succeed was because of the weak position of the United Kingdom government numerically in the Parliament. When you have a strong government in terms of numbers, these things are unlikely to happen unless it is a policy of the government itself. But when the government is always teetering on the brink of collapse and has to rely on the support of other or opposition members to keep it in office, these sorts of things can happen. And so, Mr. Speaker, that was the genesis of the concerns. We engaged, the Cayman Islands government engaged, again, the services of Sir Geoffrey Jowell, QC, to help us look at ways that we thought we could strengthen the Cayman Islands government's hand with respect to these matters. What protections we could include in the Constitution that might give the United Kingdom Parliament, or indeed others, some pause before they sought to intervene or interfere in what are generally matters devolved to the local government. And so, Mr. Speaker, the package of proposals that are contained in the draft constitutional amendment order, which we are debating today, are generally aimed at doing that, strengthening and underlining and emphasizing the autonomy of the local government to make decisions that are within its domestic policy, restricting the ability of the UK governor to essentially interfere in decision making which is not within his or her special responsibilities. And indeed, even with respect to the areas which are within the special responsibility of the governor, requiring him or her to consult with the cabinet before making critical decisions. We did take the opportunity, Mr. Speaker, to address some other areas where we felt the Constitution could be improved, but those really were not the focus of this constitutional modernization or constitutional reform initiative. Areas like, Mr. Speaker, including provision for police services Commission are some of those areas that, or was one of those areas that fall into that particular category. So, Mr. Speaker, as I go through now what the proposed changes are, it is important to bear in mind that they are a package which is aimed at essentially what I've just discussed. Improving the hand of the Cayman Islands government, ensuring that it is understood by all that the Cayman Islands government has autonomous authority in the areas which have been devolved to it, and improving the stature and image of this legislature and giving it greater autonomy over its own processes and procedures, which, Mr. Speaker, I should say, by the way, I hope will be bolstered by the independence of the legislature's bill, which I am hoping will be able to bring to the House in the first quarter of next year. So, Mr. Speaker, I know that I have been through most of this before when I laid the letter from Lord Ahmad and the draft order on the table of this House a few weeks ago. But I think this debate is important enough, indeed, some will say historic, and as such, I should go through them again with some particularity. Mr. Speaker, I will not follow the order in the way that this has been presented, but instead, Mr. Speaker, will approach this, what I say about this, in the context that I have already set out, which is what is the principal focus of these measures, of these proposals, and in the order of importance that I attach to them. Mr. Speaker, I believe one of probably the most important provision that we are seeking to include in the Constitution involves the amendment of Section 44 of the Constitution. Section 5.3 of the draft order provides that Section 44 of the Constitution of the Cayman Islands, which deals with the Cabinet, is amended by adding the following new subsection after subsection 4. For the avoidance of doubt, it is declared, subject to this Constitution, that the Cabinet possesses autonomous and exclusive capacity in domestic affairs for any matter that is not one of the following: A special responsibility of the Governor under Section 55, subsection 1, and that, Mr. Speaker, involves the responsibility for the public service, for national security. B, a function which the Governor must exercise under this Constitution or any other law in his or her discretion or judgment or in accordance with instructions from Her Majesty through a Secretary of State. And C, a function which the Governor is empowered or directed, either expressly or by necessary implication, to exercise without consulting with the Cabinet, or to exercise on the recommendation or advice of or after consultation with any person or authority other than the Cabinet. So, Mr. Speaker, what that new provision does is to make it clear that in areas of domestic affairs, areas which have already been responsibility, which has been devolved to the Cabinet or the government, the Cabinet has autonomous and exclusive capacity Mr. Speaker, following that, I believe the hard-fought provision which will become a new Section 126 in the Constitution is also very, very important. That new section, Mr. Speaker, will be entitled Notification of Proposed Acts of Parliament Extending to the Cayman Islands or Orders in Council Extending Such Acts of Parliament to the Cayman Islands. And the new 126, subsection 1 will read, where it is proposed that A, any provision of a draft act of the Parliament of the United Kingdom should apply directly to the Cayman Islands, or B, an order in council should be made extending to the Cayman Islands any provision of an act of Parliament of the United Kingdom. The proposal shall normally be brought by a Secretary of State to the attention of the Premier so that the Cayman Islands may signify its view on it. And then subsection 2 goes on. This section does not affect the power of the Parliament of the United Kingdom to make laws for the Cayman Islands or the power of Her Majesty to make an order in council extending to the Cayman Islands any provision of an Act of Parliament of the United Kingdom. Now, Mr. Speaker, the new Section 126 directly addresses the concern which was raised by us about the United Kingdom Parliament seeking to legislate for us in areas of domestic responsibility, areas for which responsibility had already been devolved by the Cayman Islands Constitution Order 2009 to the Cabinet or the government. And so, Mr. Speaker, what transpired in the United Kingdom Parliament with respect to the Sanctions and Anti-Money Laundering Bill by them tacking on an amendment which affected local legislation here to occur again, the United Kingdom government would be under an obligation to bring to the attention of the Premier that proposal and for the Cayman Islands Cabinet to have to be required to signify its view on it. Mr. Speaker, this indeed falls short of where we wished it to be, because what this does is require consultation, but ultimately the decision-making still remains with the United Kingdom on these issues. But what it will do is to, without question, cause the UK Parliament or indeed the government to pause before they seek to make legislation which impacts the territory. It will provide a period of cooling off. It will provide a period where there can be arguments, strong arguments put by the Cayman Islands government about why this should not be allowed to proceed. The UK government was not very willing, Mr. Speaker, to even make this concession. And indeed, I can say to this House and the broader public, the initial draft order which was sent to me on the 6th of January last year did not include this provision. It included almost every other provision that is in this current draft. But myself and the government and our advisors did not believe that we would have come close to succeeding in achieving what was the main objective of the engaging the UK in these constitutional discussions in the first place had we accepted that first offer. And it has taken since then until the 10th of November to get us to this point. I believe, Mr. Speaker, it is one of the most important concessions the UK has been prepared to make. It appears in no other constitution order of any other overseas territory, although the UK has signified to me that they, having made the concession to the Cayman Islands, they will offer it to the other territories as well. And I'm sure my colleagues in the other overseas territories will welcome that groundbreaking concession. Mr. Speaker, in a similar vein, the UK has agreed that the governor's reserved power contained in Section 81 of the Constitution to legislate for the territory in the areas of his special responsibilities should be revoked. So, Mr. Speaker, to use the example I gave the other week, under the current Constitution, the governor has the power contained in Section 81 of the Constitution to pass legislation in areas of his special responsibility. I shouldn't say pass, to effect legislation if the Cabinet and this House refuses to do so. So, as an example, if the governor decided that there should be certain provisions in the police law relating to bail, relating to the powers of arrest, as an example, but we disagreed with them, we being the Cabinet and this Legislative Assembly, he could, with the permission of the Secretary of State, simply draft the amendment to the law, or the law itself, if that were the case, and publish it. And that would become the law of the Cayman Islands. Similarly, with respect to the public service, if there were provisions in the public service management law that the governor did not like, or it did not contain provisions which he felt it ought to have, he could use that power under Section 81 and make those changes. It would not matter whether this legislature agreed or didn't agree. It is, in fairness to the UK, a power that has been very sparingly exercised, but it has been exercised at least once since I have been elected. And that related to changes to the ICTA law, Information, Communication and Technology law, authority law, with respect to bugging, I guess you want, is the common term, phone tapping. So the UK has agreed to remove that, to revoke that power. And the trade-off for that, Mr. Speaker, which I know not every member of this House welcomes, the trade-off for that is to give the governor the right to address the Parliament with the permission of the Secretary of State in the circumstances where the governor proposes that there should be such changes, as I used it by way of example just now, and the Parliament and the Cabinet decides that we will not, or we do not wish to do so. This would give the governor, with the permission of the Secretary of State, the power to come to this House to explain to us and the public why it is that he and the UK government believe these changes should be effected. But it would not give him or the UK government the power to make those changes. And so, Mr. Speaker, it is a trade-off, and we believe on balance that while it is not something that we rush to embrace, it is preferable to the current situation where the governor can simply act and effect legislation. Mr. Speaker, another significant concession which we believe again underlines and reinforces the authority of elected members of this parliament to decide on what legislation, what legislation should look like and what it should do. Is the concession which removes the power to disallow legislation which has been passed by this legislative assembly. Mr. Speaker, that provision is contained in Section 80 of the Constitution. And so, which I think, Mr. Speaker, for completeness, I should perhaps read. Section 80. Section 80 of the current Constitution, Mr. Speaker, reads Section 81. Any law assented to by the governor may be disallowed by Her Majesty through a Secretary of State, but no law shall be disallowed until the expiration of a reasonable period notified by the Secretary of State to the governor with an explanation of the difficulties perceived by the Secretary of State, and the governor shall forthwith advise the Speaker of that period and those difficulties in order to give the Legislative Assembly an opportunity to reconsider the law in question. So, Mr. Speaker, the way that laws get passed is that a bill is promoted in this Legislative Assembly by a minister. The bill, notice of the bill must be given to not just members, but it must be published 21 days in advance of the meeting at which it will be debated. Members debate it. It goes through the various readings in this House, first, second, third reading, committee consideration of it, and then this House passes it. That bill is then reviewed by the Honorable Attorney General, who gives advice or a certificate to the governor that in his or her view it is constitutional. And the governor then, in the normal course of events, assents to the bill. But beyond that, the Secretary of State, FCO, then has the authority to disallow the legislation, notwithstanding that it's gone through all of those various steps. Section 80, that's Section 80. The provision in the draft Constitution order in Section 12 will revoke that power of the UK to disallow legislation which has been passed by this Legislative Assembly and assented to by the governor. Mr. Speaker, the trade-off for that has been that the UK government, in this draft order, Section 11, has insisted on increasing the notification period for the bill from 21 days to 28 days in order to give themselves greater time to consider the matter before it proceeds to debate here. Mr. Speaker, I believe members of the opposition and the broader public will welcome that increased period of notification, because essentially now a bill has to be published a month before it can be considered in this Legislative Assembly. Mr. Speaker, we took the opportunity here to clarify what is somewhat confusing provision in the current Constitution with respect to the notification period. The current Constitution says that in Section 77 that Standing orders shall require that, except in a case of emergency, every bill introduced by the government shall be published at least 21 days before the commencement of the meeting at which it is scheduled to be introduced. But no one has ever been able to say with any certainty what constituted an emergency and who decided that there was an emergency with respect to these matters. So the proposal in Section 11, Subsection 2 of the draft Constitution order will read this way: except with the consent of the governor acting in his or her discretion, signified by the Premier, the Parliament shall not proceed upon any bill, including any amendment to a bill, that in the opinion of the governor acting in his or her, sorry, Mr. Speaker, I'm reading from the wrong bit. I'll come to that, but it is Section 11, Subsection 2 of the draft Constitution order. Every bill shall be published in a government notice, and the Parliament shall not proceed upon any bill until the expiration of 28 days after the date on which the bill was so published, unless the Premier certifies by writing under his or her hand that consideration of the bill is too urgent to permit such a delay. So, Mr. Speaker, it puts the responsibility on the Premier to have to certify and explain why the matter is too urgent to permit such a delay. Mr. Speaker, the bit Section 11, Subsection 2 that I prematurely entered upon just now, I will deal with now. Section 77 of the Constitution reads as follows. Subsection 1. Subject to this Constitution and standing orders, any member may introduce any bill or propose any motion for debate in or may present a petition to the Legislative Assembly, and the same shall be debated and disposed of according to standing orders. The Section 11, Subsection 2 amends Section 77 of the Constitution by adding a new subsection which reads, except with the consent of the governor acting in his or her discretion, signified by the Premier, the Parliament shall not proceed upon any bill, including any amendment to a bill, that in the opinion of the governor acting in his or her discretion, signified as aforesaid, concerns a matter for which the governor is responsible under Section 55(1), or a matter that by law is the responsibility of the governor. In the event of a dispute concerning whether a matter falls within the scope of Section 55(1), the Premier may refer the question to a Secretary of State whose decision on the matter shall be final. Again, Mr. Speaker, that is to deal with situations where the governor has special responsibility for, as I said, for the public service, for the police, and those things. Under Section 81, the governor has currently the ability to legislate for those areas if he cannot get the agreement of the cabinet and the legislature. This constitutional change now will take away that right and authority. So this introduction of this new subsection is to say that we, the legislature here, cannot proceed to amend, for instance, the police law or the public service management law or any of those that are within his special responsibility without his agreement. If there is a dispute about whether that is a real matter within his remit or not, the Premier has the authority to refer the matter to the Secretary of State for a resolution of the matter, whether or not this really falls within the governor's special responsibility or not. And so, Mr. Speaker, we will see that there is a significant reduction in the overall power or authority of the governor to interfere in the making of local legislation. Mr. Speaker, another significant change is with respect to the making of standing orders of this House. Currently, this legislature cannot make standing orders unless we have the approval of the governor with respect to them. And Section 10 of the draft Constitution order proposes to remove that authority of the governor so that this legislature will have the ability going forward to make its own standing orders without having to get the governor's approval. Mr. Speaker, the Section 4 of this draft order amends Section 32 of the Constitution, which relates to the areas where the governor is required to consult with the cabinet in the exercise of his functions, of certain of his functions, and increases the areas where the governor is required to do so. And I emphasize it is consultation. It is not that the cabinet would have the power to stop the governor from doing whatever it was he proposes in exercise of those particular functions, but it requires him to consult with the cabinet so that the cabinet, and by extension this legislative assembly and the broader public, are aware of what it is he is contemplating doing in exercise of those particular functions. And those are the functions, the special responsibilities under Section 55, as I say, that relate to the public service, to national security. And let me just quickly read Section 55 so everybody remembers. The governor shall be, Section 55(1), the governor shall be responsible for the conduct, subject to this Constitution and any other law, of any business of the government with respect to the following matters: defense, external affairs, subject to his ability to delegate authority in that regard, internal security, including the police, and the public service. So in those areas where he has the authority to act, he now has a responsibility to consult with the cabinet to tell us what it is he proposes to do. So, Mr. Speaker, the other, I think, very important in terms of image and standing and perception concession is that the UK has agreed to the change of the name of this august body, the Legislative Assembly of the Cayman Islands, to Parliament. As I've said before, image is important, standing is important, perception is important. And the term Legislative Assembly connotes a less, connotes an inferior legislative body to that of a lesser, to that of a parliament. And I think we will all welcome and embrace that, not just in the context of dealing with the UK Parliament, but more broadly as we do business as elected members locally and internationally. Mr. Speaker, the other important provision, I believe, given the increasing volume of work which ministers have to deal with, is the proposal to amend Section 41 of the Constitution to increase the number of ministers from 6 to 7, plus the Premier, although we have agreed amongst us that that provision should not come into effect until after the next general elections. And then, Mr. Speaker, there are some I move on to deal with the other few matters which have been tacked on really to this overall package. And that is some cleanup provisions that are clarifying provisions which make it clear that the functions conferred on the Cabinet Secretary may be exercised by any of his staff to whom the responsibility has been delegated, and that is contained in Section 6 of the draft order, which will amend Section 48 of the current Constitution. And Mr. Speaker, we've had the practice for 3 terms now of using councillors who operate as assistants to ministers and carry out very, very important work. We have persuaded the United Kingdom government that we should introduce the concept of parliamentary secretaries, which is the generally understood provision across the Commonwealth for what are essentially assistants to ministers. And the draft constitution order will introduce a new section 54A to the Constitution, which will create this new office. Mr. Speaker, there's also an amendment proposed to Section 58 of the Constitution by Section 8 of the draft Constitution order, which makes it clear that the governor shall be bound by decisions made by the National Security Council with respect to national security issues unless he's instructed otherwise by the Secretary of State. And then, Mr. Speaker, there's also a new provision which would be a new Section 58A introduced by Section 9 of the draft Constitution order, which 58A and B, which creates a public service commission. So, Mr. Speaker, this will require that decisions that are made with respect to the police service are no longer the sole responsibility of the governor, but of, the Police Service Commission. I said public service. Police service. So Section 58A will say, there shall be in and for the Cayman Islands a Police Service Commission, which shall consist of A, the governor as chair, B, 3 members experienced in matters of the police, law enforcement, the criminal law, or other matters relating to national security, 2 of whom shall be appointed in writing by the governor, acting in accordance with the advice of the Premier, and the other in accordance with the advice of the Leader of the Opposition. And C, 2 members with qualifications described, as I just described, appointed in writing by the governor, acting after consultation with the Premier and Leader of the Opposition. And so, Mr. Speaker, something I know many of us in this House, certainly the older members, have always thought would improve the whole accountability of the police service by having a group of citizens as part of the decision making about how the police service operates. So, Mr. Speaker, I think I have covered all of the provisions that are contained now in the draft Constitution order, and I hope that it has been helpful to members and the broader public and their understanding of what is actually proposed. I do believe, Mr. Speaker, that when this is done, which I expect, if things go according to plan, should be sometime towards the end of February next year, that the Cayman Islands overall will be in a much better place with respect to its local administration and with respect to its relationship with the United Kingdom government, and that this Parliament and the government and the people of these islands will have the benefit of knowing with increased certainty that the key decisions which are taken that affect their lives and livelihoods and prospects and that of their children are being taken by people who are elected by them and whom they can hold accountable. Mr. Speaker, I even though I've just introduced the motion and there's, I presume, much debate to come, I still wish to thank all members, and in particular the former leader of the opposition and the current leader of the opposition, for their cooperation and willingness to sit with me and sit together and put whatever partisan politics there are, and there are always those things, that's the nature of this business, to put them to one side and to agree to act in concert to further the interest of these beloved Cayman Islands and the people that we are sworn to represent. Thank you, sir.
The motion is open for debate. Does any other, the Honorable, the Leader of the Opposition? You want to start now, or you want to have the lunch and then start? But
Thank you, Mr. Speaker. Mr. Speaker, let me first of all thank the Premier for his presentation of this motion and on the proposed changes to the Constitution. Mr. Speaker, I believe it's prudent that I start my contribution thereto with my position in the past and to explain why I have reached the position that I currently have regarding changes to our Constitution. Mr. Speaker, when this subject was brought to the fore as a result of the obvious overreach by the Parliament of England, I too became extremely concerned that our political position and relationship with England was becoming strained and possibly bursting at the seams. I therefore recognize that in some manner we had to try to come to some agreement with England on the behavior or more so the provisions where parliamentarians in England felt like they could move legislation on the floor of Parliament in England without even the right of consultation or response from us. I recognize then, as I do now, that the days of the colonial overreach has long passed. These are modern times. And I have always supported the fact that this country must, at all times, have autonomy over its direction. I believe that then, and I believe it now. Whilst respecting and understanding that if we are to maintain a relationship with England, that England will always have veto power. That we will not get away from. Mr. Speaker, having said that, I was not involved in the early stages of any discussions. It was not the fault of anyone. On the day that the then leader of opposition was invited by the Premier to discuss these matters, I was not available. Therefore, I did not get any intricate details as to what we were going to propose. I was asked by the leader of the opposition then to accompany the team to England. For whatever reason, which I can no need to traverse that ground, I didn't go. But I did say that if I was going, I wanted to meet with the Premier to find out how this was going to be conducted. This is subsequent to having received the outline proposals by the government. Having met with the Premier and expressing my concerns on some of those proposals, which I trust that they understood, I still did not go to England at the negotiation table. And whilst there, the leader of the opposition then kept us up to date, albeit limited because it was by phone. Mr. Speaker, upon their return, the leader of the opposition gave us a folder which included the meetings and the agendas and the whatnot, and all of the information that we had had before, in addition to a memorandum outlining the broad discussions. In there, I found a few that, in my view, were objectionable. In particular, one about the removal of Section 81 with the caveat to allow the governor to address Parliament in certain circumstances. Having received that broad understanding of the talks, I requested a briefing from the then leader of the opposition. The leader of the opposition arranged a briefing. However, through no fault of his, circumstances overtook the opposition, not the leader of the opposition, but the opposition. And that meeting which was scheduled for February the 7th, never occurred. So I rightfully took the view, I believe, that I was not supporting any governor to come to this Parliament at will to address the elected representatives. And the other one, and I publicly made that known, and the other one was the parliamentary secretaries. And I will talk on that in a little bit, but I'm just going through why I took a particular position. I had no understanding from the broader perspective as to agree that councillors be renamed parliamentary secretaries by new section 54(6). Now, Mr. Speaker, I took that position because knowing Erskine May and understanding that parliamentary secretaries, nor private secretaries, are allowed to sit on Public Accounts Committee. That applies in England, but that can apply in England because of the number of people that elected representatives, parliamentarians. They have much to choose from. And my concern was whether or not these were going to have constitutional responsibility like ministers or junior ministers is by convention the usual protocols. I had concerns about that. I had concerns about the provisions for 8 ministers, which I expressed to the Premier prior to his departure for England. I had concerns because if we follow the nomenclature, the convention that Parliament enables cabinet, and Parliament is enabled by the people, then the provisions to remove cabinet get slimmer and slimmer as night follows day, by additional ministers being appointed. Those, in particular, those three were my broad concerns, but I certainly didn't have any concern about us negotiating and enjoying and hopefully getting additional autonomy. So upon the Premier, I think, receiving the draft order, I think it was the 18th of November, 10th of November, and his delivery and laying of that on this table of this Honorable House, I studied it extensively because we were right in the middle of a throne speech debate. As a matter of fact, I delivered my response to the debate that day. So by the weekend, I had reviewed the draft orders and understood them. On the 18th, I addressed this matter with the Premier in a private meeting with the Premier. He, like many people in this country, was surprised that I would want to leave things like Section 81 in the purview of the governor, based on what he had heard me say on the radio from my previous position. And I assured the Premier that he was completely wrong and had changed his position that he knew I had. I've always supported us gaining as much autonomy as possible. And I, for one, like he knew, does not support overreach by any governor, be it this one, previous, or those to come. The Premier and I have had our share of negotiations in the last 19 years trying to move this country forward with more autonomy, particularly the one he talked about, the more recent ones, 2008 and 9, when we, the two of us, fought very hard to make the governor a ceremonial governor. That is for him or her not to sit in cabinet. We have been on that fight since 2000, 2002 or thereabouts. We have not been successful, and thus he has not been successful now again. I believe if we fight long enough and hard enough, at some stage one will be rewarded. Hard work brings reward. And one day, we will see the governor in this country as they are appointed to Bermuda. and cabinet will, at long last, be chaired by whomever the premier is. That is domestic liberation. Mr. Speaker, I sat with the Premier and expressed the concerns that I still have. And I still have those concerns, and I will elucidate on them here in a few minutes. Mr. Speaker, I should clear those off the table before I go into any detailed debate on the rest of the proposed changes. Mr. Speaker, the Premier, I don't know if acquiesced is the right word, but he agreed upon my request. And I want to make that very clear, Mr. Speaker. The Premier understood that to get these changes through, despite me supporting 90% of them and having concerns with the other 10%, that he needed the opposition to support those, all of them. And I want this country to know, I want those in council in England to know, and it was upon my request that the Premier acquiesced or agreed, like I said, to us postponing the 8th minister till after the next election. And whomever gets elected can address that matter. Mr. Speaker, my concern with the 8th minister and our current constitution, which requires a 2/3 majority to remove the Premier, is something we need to look after whomever enters these hallowed halls after the next election. Mr. Speaker, I'm concerned that because of the composition of this Parliament, which is 19, that the 8th minister puts it further out of reach of this Parliament to exercise the balance of power. The balance of power must be vested in all the other members of this Parliament, this legislature as it is called. Cabinet is enabled by Parliament. I explained to the Premier, Mr. Speaker, that if we find ourselves, we can only make provisions for a simple majority the government is made up of. That is the only way government operates. A simple majority means there are 10 people in the government and 9 in the opposition. Mr. Speaker, when we have that balance, that makeup of this legislature, 10 in the government, 9 in the opposition, whether it's 1, 2, 3 parties, independents, there are 9 in opposition to the government. if we require a two-thirds majority, it requires 4 members from the government to vote with the opposition to remove that premier. Because we cannot remove the government, we remove the premier and the government falls. And the government is removed. Mr. Speaker, that requires 2 members out of the cabinet. I should pause here to say, Mr. Speaker, that I was a proponent of that two-thirds majority in the last constitutional negotiations, 2007, 2008, 2009, because I too then believed that we should not have musical chairs with a simple majority. Mr. Speaker, having had the opportunity to watch this Constitution work for the last 10 years, I believe it's time that we go back to the table. And I believe that, like was done in 1999, 97 I think it was, when the Constitution was changed, the 1972 Constitution was changed. The two-thirds majority was 10. And the legislators of that day in their infinite wisdom changed it. The removal of a government member. In those days, it was members that could be individually removed because they were voted on to go in exco. The legislators of that day moved that from 10 to 9. And that remained until we got a new constitution in 2009. Most people may not remember that, but that's a fact. It was not a two-thirds majority to remove a member from cabinet. It only required 9 out of the 15. We have come a long way since. We have now 19 members. Mr. Speaker, the problem we have, and we need to address it with England, the United Kingdom, is that as a simple majority, we are faced with the probability, the high probability, that one of those members will walk and we have a minority government. That means 10 will be in the opposition and the government would only be 9. That's the kind of system, that's the kind of balance of power that we are faced with, and the possibility of it changing at the whim and fancy of one individual in this parliament. And if we extend that further, Mr. Speaker, and we do have 8 ministers and 2 backbenchers and 9 opposition members, and those 2 backbenchers leave the government, and we subscribe to the concept, the convention, that Parliament enables the cabinet, then those 11 should be able to remove the premier. because that means all of the rest of Parliament, which enables the cabinet, has now moved from the government. And they're in opposition to the government. We don't have a lame duck government anymore. We have a minority government that cannot and will not get anything done. That is why the Premier agreed with me with my suggestion to postpone the minister until after the next general election in order that we can address that matter again. I thought it was quite a bold move on the part of the Premier to agree with that. I thought maybe it was bordering on brave, knowing that he has a large majority in this honorable House, and he has members that he could pick from to put as the 8th minister. And he could reshuffle his cabinet and put another person where they were best suited and someone where they could, and relieve him of that responsibility of the minister for almost everything that he is currently tied down with. I thought it was magnanimous on his part to subject himself to that, having negotiated it for so long and so hard. And I thank him for understanding my position and appreciating that balance of power, that is governance, that is what we are paid to do. Mr. Speaker, I would not, and now I speak to the people of this country, I would not support anything that is not in the best interest of this country. I came to these hallowed halls with certain commitments. And one of them was that I would not postpone my principle when it comes to the betterment of this country. And I know many others, all others, consider that paramount in their life also. Mr. Speaker, the other concern I had was that of the governor reserved powers to legislate law. And the Premier was little concerned that, knowing me, he thought that what I'd said on the radio was out of character, should I say. And after explaining it to him, then he understood what I meant by that. When I said to the public that I was not going to support anything where the governor can come to this parliament and at the drop of a hat between however that is affected and address our parliament except once a year or once every 2 years now, which is the throne speech, which is managed by the political director. Mr. Speaker, I still have concerns about it, but certainly in the spirit of appreciation for the long, lengthy discussions between this country and the United Kingdom, I too, like the Premier, has had to make some concessions, and maybe later we need to address it. No, maybe we need to address it. Mr. Speaker, United Kingdom has veto power over this country. That is expressed repeatedly in our Constitution and is further expressed in these new amendments, these proposed amendments. If we look at them, these and the Constitution, they maintain that. They will never, ever, ever give that up unless this country makes that bold move to go towards independence. Mr. Speaker, I didn't support any governor. For that matter, some of them that I have had to deal with, I wouldn't support them managing anything for me. I didn't support a governor having that authority over this legislature to make law, as was the case in 81. Because, Mr. Speaker, that lends to exactly what the Premier spoke of earlier, in that when there is overstep on what that responsibility is, that can happen anytime. The governor could very well say, well, that is my responsibility, but it borders whether it's his responsibility or this Parliament's responsibility to amend or make law in a particular area. And with the distance between us and the Secretary of State, anything could happen. So I didn't support that. Still do not support a governor doing that. I explained to the Premier that my fear is twofold. One, whilst the governor has his responsibility and has the right to make law under Section 801, currently, that is, after consultation with the Secretary of State, there is a definitive action. He can make the law. As a result of that responsibility that has been given to him. And I think, Mr. Speaker, I should pause here to say that this is the section of the Constitution that we couldn't negotiate in 2008-9, which was mirrored from the old Constitution, from the 72 Constitution. There were very little changes made to it. This is one of those sections. We had to accept that. Mr. Speaker, here is my concern with any governor, for that matter, coming down to this Parliament. The fact that Section 801 now allows the governor to make laws, albeit under Section 55. The only reason the governor would do that, which is expressly written in the Constitution, is that there's a conflict between the governor and the cabinet as to whether or not the cabinet should entertain him and take it to the legislature for passage. That's the only reason he would exercise that provision, he or she. Mr. Speaker, what escapes me in this one, this change, is that we are faced with the exercise or entitlement of the governor to come to Parliament and address it on matters relating to his responsibility. When it comes to the enactment of legislation. Mr. Speaker, here's where I'm at with it. And the Premier knew that I was going to express my concerns. This is no news to him. Mr. Speaker, we are made up of 19 members. If this governor, or any governor, if a governor is allowed to come to this legislature, having left cabinet, having a conflict between him or her, and the cabinet, there is no stated objective in this for coming to this Parliament and addressing it. That concerns me. It seriously concerns me. And regardless of what happens at the next general election, whoever comes in here must address that. Mr. Speaker, the concern I have is that this country, and many may say that its political harmony and success comes from being under England. But Mr. Speaker, it is also true that political harmony in this country comes from the reasonableness of the people within this Parliament and those that were elected by the people of this country in this legislature. Mr. Speaker, I have had governors that I've had to deal with in this country over the last 30 years maybe. That weren't worth the salt you put in your pot. Mr. Speaker, my fear is that intentionally or not, a governor coming here to address the members could disrupt our political harmony. And at the same time, has the right to write Secretary of State without coming to this legislature and exercise, and the Secretary of State can then exercise the veto power by virtue of proposing legislation. However, the provisions makes need now for the consultation of the Premier and by extension the country. Mr. Speaker, when all is said and done, I would prefer that to happen because it is available to any governor. So I would like to see 80 totally remove and they rely upon 81, I think it is. And the reliance directly upon the veto power in England, which gives us that right to respond through consultation. We may not get it, but if we are to be an overseas territory, then we must recognize and respect that that veto power will remain.
Mr. Leader of the Opposition, I find that this is a convenient place to take our luncheon break, and we shall suspend until 2 p.m.